Thanks again for joining us today. So for those of you who don't know me, my name is Jessica Zaratsky, and I'm located in the Wisconsin offices. And Buffy Klein, who is in Texas, and I are going to give you some information today on forbearance agreements. We think that this is a timely topic because one of the main questions that have been floating around these past 6+ weeks as we get into responses to COVID-19 has really been, how do we get everyone through this first handful of months of uncertainty? So the focus has really been one of short-term solutions and focusing on immediate needs and immediate fixes in an attempt to stabilize borrowers and lenders, and with the hopes that by putting these band-aids on, maybe these will be enough to quickly restore the economic activity and minimize the operational and financial distresses that we're starting to see. But I think that with each passing day, we're really seeing that and realizing that these short-term fixes are not going to be enough, and that we need to start preparing for the long-term effects on borrowers and on lenders. And one of the examples is that these loan modifications and amendments that were being put in place in March and April are going to start expiring soon, but borrowers' problems will not be expiring at the same time. And so they're still going to be suffering from cash flow shortages, and they're going to be struggling to service their debts. They're going to be out of compliance with their loan documents, and they're going to be facing a new normal and an uncertain future. And so under these circumstances, restructuring and modifying the loans again may no longer be an option. And a lender may be left with no other choice but to call the defaults and to put a borrower into a forbearance situation. So Buffy and I are going to give you guys a high-level overview of when forbearance agreements come into play, generally what they are, and then we're also going to highlight some of the common yet still very important terms of a forbearance agreement. And we've shared with you ahead of the program today a short outline. We're going to run through that. And we've also shared a short form forbearance agreement. And we think that this is just a good basic example of where to start. But obviously, these types of documents really need to be customized to each circumstance. So, and then hopefully at the end of all this, we have time to answer a couple of questions if you have them. The chat room is open, so you can feel free to type any questions you have in there. We'll try to get to those, and if we can't, then we can certainly tag with you guys offline. So with that, I will hand it over to Buffy.
Great, thank you, Jessica. So as Jessica pointed out, we're kind of entering into a time where there are going to be a lot of discussions between borrowers and lenders. Some of these borrowers came into the current environment healthy, and now they're experiencing different things like business interruption issues, market impacts, supply chain problems, cash flow obviously is an issue. Some of these borrowers, unfortunately, came into this environment already experiencing some of these problems. Obviously, we've had a very healthy economy, but that doesn't mean that every business has been experiencing the same level of success. So some are going to be ahead of the curve in entering into these discussions with their lenders. So a forbearance is often, when it becomes necessary, is often to address the things Jessica pointed out. Really, it's going to come into play oftentimes when a borrower has a really good history with their lender, or the lender sees some potential for this borrower to resume normal business operations. A forbearance is not necessarily, a forbearance is really a period of time. There's no one definition of a forbearance. And so a lender is going to look at this request by the borrower. Well, oftentimes it comes as a request by the borrower. Sometimes it may be a lender that recommends that we move into a forbearance period. But generally, it's not a yes or no, we'll do forbearance, we won't. Generally, that's the beginning of a discussion on terms that are going to provide adequate protection for your lender to provide for the continuity of the relationship. It's going to give them, an opportunity to review the documents and to determine what issues need to be addressed as they move into that type of a relationship. In order to do this, the borrower is going to acknowledge the default. That's a big piece. So that's what a forbearance really encompasses a lot of times, is that acknowledgement of the default, the agreement that they have to reach a new type of a relationship so that they are kind of on pause, so that there's some room for the business to recover. And the lender is oftentimes given the opportunity to address some of the shortcomings that might have been in their file at the time. Documents that are deficient, perhaps intercreditor issues that have arisen or become apparent. So these are things that these are oftentimes what's encompassed within that period of a forbearance. So I think given that, I'll turn it over to Jessica and we can start talking about some of the terms that we often hear when we're talking about a forbearance.
Right. And a lot of these times are going to, be designed to assist a lender in any number of circumstances. One of those is going to be to closely monitor the borrower and the debt and collateral. Lender is also going to want to increase its leverage, strengthen its position, minimize its risks, and then, ultimately at the end of the day, collect on the debt as quickly and efficiently as possible, if and when that time comes. So jumping into some of the common terms, it's really important to start off both in the whereas clauses and in the early provisions of a forbearance agreement to really bring everything to the forefront, to set the stage and just make sure that the borrower and the lender are on the same page when it comes to these key items. And so a lot of times this will be done via various acknowledgments and affirmations. I want to highlight 3 important ones that we run into very often and need to be cognizant of. The first is an acknowledgement and affirmation of the debt. And what that is that we've got current amounts. We need an acknowledgement and affirmation where the current amounts and the outstanding debt are itemized, including principal and interest occurring at the default rate, and all other costs and fees, and importantly, the attorney's fees. And we've got the borrower agreeing that the current amounts due and owing, and then taking it one step further, that the amounts are, due and owing to the lender immediately without defense, offset, or counterclaim. And one of the goals in doing this is to try to avoid or resolve any disputed balances, whether that's now or that could pop up down the road. Forbearance agreements should also contain provisions that the borrower acknowledges the firm defaults, and then the lender's rights and remedies as a result of those defaults. So the defaults should specifically, and it's important to not just generally identify defaults. Those defaults should specifically be laid out and identified in the forbearance agreement. And then the borrower acknowledges that those specific defaults have occurred, that they're continuing. They go on to acknowledge that the lender is entitled to exercise its rights and remedies as a result of these defaults, not only under the loan documents, but also under applicable law, that the lender is not waiving these defaults or rights and remedies. That's important. Also, that lender is not obligated to make any additional advances, but that if the lender does decide that it's going to go ahead and do so, an acknowledgement that the lender is doing so under a reservation of its rights and it's not waiving any defaults. And one of the goals with these types of acknowledgements is to really be able to track the current and the future defaults, so that if a lender act And then also just to avoid any future disputes or potential defenses that could arise relating to the defaults. And then third, Buffy is going to talk in a little bit about some circumstances under which a forbearance agreement can be used to amend certain terms of the existing loan documents. But we want to make sure that those amendments are limited to only those that are specifically being identified in the forbearance agreement. And we don't want to have the forbearance agreement be viewed as a complete amendment of all of the existing documents. So it's important to have the borrower reaffirming and acknowledging that the existing loan documents continue to be valid and binding and enforceable against the borrower in accordance with the terms of those agreements and without any defense. And then the lender will want to see that the borrower acknowledges that the lender, has complied with the loan documents, with applicable law, and that it's acted reasonably and in good faith. And to have the borrower reaffirm reps and warranties that are contained in the existing loan documents as of the date of the forbearance agreement. So important to bring those reps and warranties forward as of a current date. And then also we want to, make sure that we've got a borrower reaffirming the priority, validity, and proper perfection of the existing security interests and liens in favor of lender, so that lender will be able to jump when it needs to and exercise those rights without the fear of having any dispute as to those liens and security interests. And so with that, I'll jump back to Buffy so she can talk about forbearance terms and conditions and amendments.
So the one thing that is going to be important is for the lender to determine what the period of the forbearance will be, because that's going to kind of set the bookends for how the relationship will be handled, and really what the expectations are during that period of time where they're trying to reach a new normal. So what you want to have is the borrower acknowledge that it has requested the forbearance and they're agreeing on the specific time period for the performance to be to be made to accomplish the goals of the forbearance. And additionally, the lender is going to agree, look, we'll forbear from exercising certain rights and remedies to the extent that there are no further defaults, because you want that to be very clear, that in the event there are additional defaults, all bets are off, and the forbearance period is only as good as the performance that's required under it. So as long as the borrower is doing as they have represented, then certainly there's going to be that forbearance of any additional exercise of remedies. So as Jessica pointed out, this is an opportunity, and it will be necessary likely to amend the existing loan documents to provide for certain things that are going to make it easier for the borrower to stay in compliance. And that may include changing the payment terms. Oftentimes you're going to see an amortization that'll stretch out that payment requirement. It may change the due date of the payment to make it easier to stay in compliance. It will likely also change the maturity date, because typically the reason that you're in a forbearance period is to allow for that extension of time to get healthy again, essentially. It will also give the lender the opportunity to look at the covenants and to revise them, to add covenants, and certainly what you see very, very frequently are additional reporting requirements, auditing provisions that allow for that lender to come in and do a more robust review of books and records. It may reduce the loan commitment, certainly. A lot of times it's also going to make it very clear that no new funds are going to be available. So all of those things are oftentimes included there. The conditions to the forbearance are what you will typically see next within the negotiation. You'll be looking at what exactly is going to be required in order to meet the conditions to continue this forbearance period. And a lot of these may be addressed through different statutes in the states in which you're operating, but you're going to, first of all, want to make certain that your borrowers have the authority to enter into the forbearance agreement. So whatever resolutions are necessary are going to be a condition to that forbearance. So you'll want to make sure that they've provided you with the adequate authority and they've executed it and they've given that to you. There may be, and this is a good time for you to talk with your client about the need for additional guarantees, additional collateral, and how that may be documented. Likewise, you're going to want to make certain that you're aware of the status of the different guarantors, that they're still within contact with the company, that they're still reachable, and perhaps this is an opportunity to get renewed financial statements from those guarantors to determine really what the opportunity be in the event of a final default. The other thing that you see often and something to consider is the retention of a restructuring officer, some type of a workout consultant. We see these become more, as the economy becomes worse, we see CROs, as you may hear that term, more frequently engaged and involved in these workouts. You're going to also probably want to require status reports, and this may be sales reports, more than just the financial part of it. You want to perhaps look to build in some opportunity to look at the actual business and how they're operating and how frequently they're, turning inventory, that sort of thing, depending on what the goal of your client is there. A lot of times you're going to want to require detailed budgets and expense cash flow reports. Cash 13-week cash flow reports. That's a very popular one to bake into these. The other thing that may be within the conditions of the forbearance is additional capital requirements, and this could come through liquidation of certain assets. It could be proceeds from other sources that are used to pay down the debt to a certain level. You may also have take this opportunity to have them execute additional documents that are necessary, or in the event you don't have the adequate signatures on certain documents, as you've heard on file reviews, it's very important to look and make certain that you've got all of the authority and the right people signing the right documents, and that that those are being kept, and to the extent that you need originals, you've got them, and to the extent you needed notaries, you've got them. You want to make sure that your liens are perfected, and that to the extent they weren't, that you've taken the steps to make certain they are during this period of time. So this is something that's also typically within your conditions to the forbearance. There may be also forbearance fees or other fees that are required on the front end to be paid. A lot of times you may see attorney's fees, a certain amount of attorney's fees that are required at this point, just because the lender wants the debtor or the borrower to acknowledge that this is a cost to them, and take some responsibility in that. You're also seeing consent and reaffirmations of your guarantors, because you do not want a guarantor to come to you later and say, I had no idea. If you'd let me know that we were going to be going into a forbearance period, I would have said, forget it. I don't agree to that at all, because I know this is a bad bet. You never know what you're gonna find, but you want to be certain that everyone that you expect to be responsible for this debt is fully aware of what's happening. And so those notices to guarantors, the consents, the reaffirmations, those are all really a key piece of this. The one thing that you want to make sure when you're looking at this is when you are taking new collateral and you're getting new guarantees and obtaining funds at this point, to the extent that the borrower is in risk of insolvency, to the extent that you believe that may be something a bankruptcy could be in the future, you want to be aware of the timing. You want to be aware of the fact that this could be a preference or could otherwise be claimed to be a fraudulent transfer. Those are all things that you want to at least acknowledge and kind of put that into your risk analysis. Finally, what you'll see in a forbearance is, there are typically other provisions that are in this that are designed to benefit the lender, typically. you're going to have a waiver of notice with respect to disposition of personal property. To the extent you have to take property, you want to have them address that here so that you can go ahead and sell it without there being additional work on your client's part. Perhaps a shortened or waiver of redemption rights, shortened period or waiver of that entirely. You want to also look to a potential for the appointment of a receiver in the event that there is, there's a default under forbearance. Entry of a judgment against them for the deficiency, entry of judgment for foreclosure or replevin of personal property, a turnover agreement. You would also want there to be, to the extent the borrower has other accounts, there is an acknowledgement of the set-off right. And there may be, to some extent, an attempt to get a waiver of the automatic stay in the event a bankruptcy is filed. These can be useful. I mean, certainly they are some evidence. You'd still have to go forward and get that from the court, but that at least at that point you can show the court that this was part of the agreement that the parties had. So with that, I'm going to turn it over to Jessica to talk with you guys about the balance that you're going to find in these agreements.
Thanks, Buffy. So just a couple of last points that I quickly address that are important and that should not be lost sight of is the release, waiver, and indemnification by borrower for the benefit of the lender. And with respect to these types of provisions, lenders will have borrowers fully release the lender of any and all claims, including lender liability claims. And the borrower will also fully waive any and all defenses to the loan documents and to repayment of the loan that it may have. And then also on top of that, borrower will agree to indemnify the lender with respect to liability that's related to the loan documents and the forbearance agreement. But it is important to note that those types of releases should only run through the date of the forbearance agreement, because a release of future acts will likely be looked at as overreaching and unenforceable. And so we wouldn't want to have that on the part of the lender. And then finally, forbearance agreements should have borrowers consenting to a specific jurisdiction and waiving its rights to a jury trial. Again, these are just provisions that can help set the stage so that if and when a lender has to pivot to a litigation strategy, then it can hopefully do so without getting wrapped up into some of these types of disputes that it could otherwise have accounted for via the forbearance agreement. I don't see that we have any questions that have come up through the chat room. So I guess with a couple of minutes left here, I'll just have Buffy wrap this up.
Great. Well, I think in conclusion, I hope this gives you at least an overview of what to expect. I think that those of us who have seen economic downturns in the past acknowledge the benefit of the forbearance. I mean, certainly it not only provides a tool for the borrower to try to bridge these rough patches that they're experiencing and that they will experience. We're going to see this regardless of how the economy ultimately reacts. We're going to see different borrowers that are just unable to withstand 2 months or 3 months or 4 months of non-operations. So I think that what we're going to see is lenders taking the opportunity to help their borrowers through this period of time. They're going to take the opportunity to utilize this time to make certain that they're in the best possible position. I think that probably will be different in that these are probably everyone is experiencing this, so there will be a little bit of a our lenders are going to be taking a different stance because they can't afford to default every borrower they have either. So there will be I believe a more measured approach, and this is a tool that our clients can use to accomplish that. I did see we had one question, Jessica. about the points that typically get negotiated. And I think from my perspective, what I see a lot of negotiation on is typically it's the amount of payments and how those will be reduced. That's going to be the key piece. But a lot of the issues, surprisingly to me, are the reporting requirements. You know, that so your lender wants an enormous amount of information. They feel more comfortable with more information, and the borrowers see only business interruption and the need to provide that reporting. So what's your take on that, Jessica?
Yeah, I would agree with that. I think borrowers understand that they're, trying to operate under these circumstances and that there will be some tightening and a little more, oversight by the lender. But I think they typically try to have that, as narrow as, or as narrow as possible from the oversight point of view. So I would agree with that.
Yeah, I think as you're talking to your clients, both on the borrower side and the lender side, and if you come up with more questions that they may have or that you may have as you're trying to consider counseling these folks, feel free to reach out to either of us or to others that are in the banking, finance, the insolvency team. We're all very familiar with, historically what's worked and what have caused problems. And so we're happy to provide our knowledge on those points.